is based on that public trust and confidence. His Worship, James Eremie, who is the Public Relations Officer at the judiciary, is here with us this morning and is going to be talking to us about everything on the National Court Open Day. You're most welcome to Morning at NTV.
Thank you very much. How are you?
Great.
That's good.
Yeah.
Yes.
My preamble is one that stretches from extremes to bends.
Yeah.
And I like when the poor man gets assurances that whichever condition you're in, you must be able to win a case. Many believe it's about money, but I think it's a case of access to, say, a lawyer, and which particular lawyer you want. Legal aid does cater for that. But quickly, let's get up to speed with what the National Court Open Day is, especially for 2025.
Well, thank you very much. Good morning, viewers. Once again, I bring you greetings from the judiciary, and we are so honored when you always join us on NTV and any other platforms when we are communicating to you, the public, the whole issue. In fact, you made a very important comment, misunderstanding. It's so sad situation that we wonder why must our people continue misunderstanding. And because the misunderstanding is continuous, we come up with innovations that are intended to remove that misconception, that misunderstanding. And this is Court Open Days.
That is
what is Court Open Days? This is the forum where the public and the court sit together for a conversation and give public accountability and demystify many of those myths and I don't know what it is, those fears, and we exorcise the devil out of the institution. It's just the devil who is bedeviling our people, some hovering spirit around which does not exist. It's imaginary. The institution of the judiciary is a pro-people institution, and we are here this morning to tell you that we are going to have the second National Court Open Day.
Wow,
yes.
That is something to look forward to, especially that
yes.
it gives the average Ugandan, including Chris Higenyi himself, an opportunity to interact
yes.
with the Chief Justice. Is that so?
Yes. The Chief Justice is the guest of honor. So,
okay.
And let me tell you this. We had the first National Court Open Day. And I want to thank the public. You people came, we were so happy that, yes, contrary to popular belief and opinion, you people, you came and interfaced with the judiciary. This is the second chance we have. Please come on the 15th of December 2025 at Kololo Grounds. Once again, Kololo Grounds. No one is expected to pay anything. It's free entry because you are going to meet your servants.
So basically, what should I expect? Somebody might be a little concerned that it would be that elaborate, rule-based interaction that we see in court, and that they should be prepared for being told, okay, please, right about now, do this, let's go into this. Or it is something that is bound to be a cordial interaction.
A very cordial interaction. There are no rules. That's why we decided to go into the ceremonial grounds.
Okay.
If we had intentions of having rules, we would have remained at courts. Now, let me tell you this. The National Court Open Day and the second one we have this time around, okay, is where we want the people to come closest to the courts. And in so doing, we are going to have this public accountability. That's where we're going to have that public conversation. That's why we are rallying the public, please come. It is Kololo ceremonial grounds, no rules, no robes. We shall be in ordinary ceremonial t-shirts, which everybody, also the members, they will partake of some, you know, so that you will all look alike. We are Ugandans. and we are supposed to serve the public, right?
All right.
So we are going to be there. So come and we talk to one another.
Now, Article 126,
yes,
according to my readings here, of the 1995 Constitution of the Republic of Uganda provides that judicial power is derived from the people,
yep,
and shall be exercised by the courts established under the Constitution in the name of the people,
yes,
and in conformity with laws, values, norms, and aspirations of the people.
Yes.
The question many are asking, does this thinking reflect today?
Exactly. That's why we have all of these innovations to try to put Article 126 into fruition, into reality, because we derive judicial power from the public. When then is best for us to interact with the public? Court Open Days is a forum for public participation in the administration of the judiciary. That's when we learn from one another. That's when we receive positive feedback. That's when we receive even the negative feedback because of the roles, the norms, the aspirations of the people. These are very core to the institution of the judiciary. And so, Court Open Days, as we have had even across the country in different regions at different court levels, this time round we have the National Court Open Day, where we shall give the state of the judiciary in the first place. The Chief Justice will give the state of the judiciary to the public to understand where have we come from, where are we, and where do we intend to be, and then also rally the public to participate along the way. At all the stages of the judiciary's development, we need public participation. And at the end of the day, we have to give accountability. Those are those days when some of these things were no speech. Today, we speak about these issues because we want the public to know we are servants of the people. We are your servants. And so, National Court Open Days and all other Court Open Days and barazas and other sensitization issues, we rally the public to come and we talk to one another. That is intended to remove completely the misconceptions.
All right. Now, if I were to face the Chief Justice or the Principal Judge or any of these powerful individuals that are often robed and covered in garb, and I have my simple questions about corruption in the judiciary, about the fact that some judicial officers seem not to want to basically offer a service on account of my inability to facilitate the process. And my questions asked directly to the Principal Judge or the Chief Justice, and an answer is provided. Must I mention names at that point, or it is something the average Ugandan must stay clear of because of the consequences?
Of course, as an institution of the judiciary, we encourage the public to bring up such information.
That's
okay,
right.
But the nature of such information is one that requires caution. Because we don't want to victimize our people who are giving us this very good information.
Through allegations.
Yes. What we do, like on this Court Open Day, you are free to say whatever you want to communicate. It's a forum for free communication, freedom of expression. It starts with the judiciary, you know. And in such an environment where one is having such an issue, when you raise such a complaint, we have mechanisms and systems, including institutions or units within the judiciary that can handle such an issue. Anyone who has a complaint about corruption or mishandling or any poor customer care issues, we have dedicated officers in the inspectorate of the courts. So we shall receive a lot of that feedback and we shall make referrals because we are interested in following up those matters, because at the end of the day, our main purpose is to improve service delivery.
Service delivery.
And so where those matters come in at the Q&A, because we shall have a Q&A session where the public, and that is going to be the biggest time around. You know, yeah, we shall do little talking because the public would like we would like the public to speak to us more. Than how we speak to them. That's why speeches are restricted to a few top leaders of the judiciary to allow enough time for the public to bring up those issues. And when they do, we shall be taking notes. And where we find reason to make a follow-up, we are going to follow up with those people for purposes of properly understanding and resolving some of those issues. Yes.
Feedback is a very foundational pillar, especially in rolling out this innovation from the judiciary. And I would like to look at the scorecard for the very first National Court Open Day. What were the issues that emerged, and how far is the judiciary in addressing those that came to the fore?
Yeah, of course, from the first National Court Open Day, most of the issues that came up were more on case management, matters of delays in the disposal of cases. Then we also had matters to do with the integrity issues of our judicial officers and other staff. We also had issues to do with the customer care issues generally, but I want to bring it to speed that over the years, okay, because last year we were unable to hold one due to funding constraints, but this year we have. Over the period since the last Court Open Day, we have come up with innovations in case management, okay, and we have made a deliberate decision to ensure that we sensitize the public about these innovations and interventions so that the people know what are those areas that are causing delays and what are these interventions that we believe will work out for some of these ones. For instance, I will give you an example. We have ensured that we roll out ADR. That is alternative dispute resolution. I will mention one of them or two. Mediation. Okay, the whole of the month of November we called it the mediation month across all courts. Okay, and we had a pilot of 9 high court circuits, including the magistrates courts in there. Okay, that was one of the interventions. November was a settlement month. And we are moving towards now getting the statistics, how far have we gone, and we shall come and give a report. I will also give you another innovation in case management, which we want still the public to take on, plea bargaining. I will tell you that already our courts are still doing plea bargaining. We have sessions where judges are moving up and down doing plea bargain sessions, and this is a very important intervention in case management. When I talk about another area like public relations, okay, in customer care, we are doing great strides in ensuring that we sensitize, train, skill our officers on customer care. And that is central, and so it's at the bottom of my heart, okay, when I see judicial officers and staff understanding and appreciating a people-centered approach to the administration of justice, and that's what we are talking about. Then other areas of integrity, we have the Inspectorate of Courts, we have revamped, okay, and we are telling the public that soon we are going to have regional Inspectorate of Courts in those regions so that they are centralized from Kampala. The other interventions which are sometimes people don't understand them is the operationalization of courts across the country. You have known that now every district is a chief magistrate's court. We are only lacking all the requisite manpower to post there, but at least the Chief Justice did his work. Then we have the high court circuits. You have operationalized several, and when judges are appointed, we shall be ensuring that all of these other places have them. You know, those are all interventions based on the previous. Now, this particular one, we expect maybe a repeat of some of them, but probably we think that the public will come up with the new issues so that we are able to take stock and move forward and go back to the drawing board. But most importantly, we want this public participation.
Okay.
Yes.
I like the assurance on the flexibility with which you'll be handling the public and the questions that might come out at any one point in time. Now,
and they should feel free.
Feel free.
Yes.
Let me get straight to being free. And of course, I might not make it to the National Court Open Day. I might. But if I don't, I have a question. And this is the political question doctrine. As Ugandans watch the proceedings in courts of law, we are left wondering why certain cases drag, appear not to proceed on account of what is never really clear and heavily seen by some actors who describe these cases as political persecution, so to speak. During this particular engagement with the judiciary, people are bound to ask this question. This is an opportunity to make some clarifications.
Yeah, you see, first of all, for us as an institution, we have cases. It's you people who classify them as such. I don't know what. And then you are bringing in the political, whatever doctrine. Now, those doctrines do exist, but they do not exist within the ambit of case management. You see, those doctrines, they are there. But when we are talking about how a case enters into our system, how it progresses through, and how it exits, it's purely a case management matter. It's not about political doctrines and economics and I don't know what. No. We have robust and dedicated case management practices across all courts. All courts are unique in their nature.
That's right.
Magistrates courts have their uniqueness. The High Court has its own uniqueness, and when it comes to the appellate courts like the Court of Appeal and the Supreme Court, which courts sit in quorums, and the other challenges of forming a quorum, you know, did you know that we can be on the bench in the Court of Appeal, but a matter that has come before us, either one of us or several of us, before joining that bench, we were advocates for parties. That's one other aspect.
Oh, interesting one.
Yes, and I want to speak to that.
Speak more about
because we have a big challenge when it comes to forming up quorums. Because the members who we may have on our benches, some of them have been involved in those cases before. Now, when a matter comes to them, okay, in the Court of Appeal, they cannot sit in the same matter. So we then develop a problem how to constitute the quorum, because then by law they cannot. You get the point?
Maybe to be as simple as we can get, so that my uncle in Butaleja
can understand, because there is, of course, the one in Butaleja, yes.
A judicial officer has been a lawyer before, or a state prosecutor, heavily involved in a case, but as career progression comes through, they are appointed a judge.
A judicial officer.
And in a way, they find themselves presiding over a particular case that has one of their former clients.
The file finds them at their station.
Are they supposed to recuse themselves?
They will recuse themselves. And so, upon a recusal, we have to find an alternative judicial officer.
What if the judge declines to recuse himself?
Of course, we have dedicated rules on recusal. If a judge does not recuse himself, he gives reasons. Yes. So oftentimes we misunderstand these judicial officers because we think they will be biased. You want to impart the thinking on them. They took a judicial oath, and it doesn't matter. But nonetheless, for justice to be seen to be done, many times judicial officers will do a self-examination, and when they do so, they will take a decision that's appropriate judiciously. And that's the point. But I want to tell you that there are several factors that impact on case management.
Okay.
Some of these are beyond the judiciary. Some of these are actually parties oriented. Some of them are other stakeholders in this case trial. You see, some of these are institutional. Okay, so when you talk about a case not progressing as fast as you want it to, I want to tell you that that's not the policy of the judiciary to delay cases, but based on other factors that may not be in the control of the judiciary, there are prone to be certain delays. And you see, for the courts, we must allow for every party opportunity to effectively present their case. We don't hurry justice, neither do we want to delay it. But we do a balancing act, and that is within the ambit and control of the judicial officer, who we have already skilled on case management. So we want to tell the public we have no deliberate policy that matters will be delayed. Ours, guided by Article 126, we shall ensure that we expedite the trial of cases, and we shall manage all circumstances that try to impede. And one of these are the innovations. We want you to come in Kololo and you listen to us, and we tell you, and you see where do you fit. And when we tell you these innovations, they have been designed for the benefit of the people of Uganda.
Basically, the e-service is one of the innovations that you have rolled out as a judiciary. Quickly, give us a scope.
And that's very good. One of the innovations has been ICT-based innovations. And e-service is under ECMIS, Electronic Case Management Information Systems. And this was an innovation intended to do, first of all, reduce the people-to-people contact, which was brooding a lot of perceived corruption. And in some instances, actual. Because you see, because you are going to meet Remy to do for you something, there is that probably that assumption that maybe I need to give him something to propel him to do whatever it is. It's never
explicitly stated.
But they assume sometimes. And those are the perceptions we want to do away. We cannot do them away with it only talking, but we also come with innovations which are ICT based. You will not have to bribe a computer. You will. But first of all, you are in your own office, your chambers. You are doing electronic service, you are doing electronic filing, everything electronically. Now, we are not only asking you, please invest in technology, talk with your computer. All the transactions, including payment of charges and fees, is done electronically. So we reduce corruption, or the perception of it. Yes.
Okay.
Now, and expediting processes, even allowing the public to be able to follow their case in the comfort of their homes and offices. That's great, even on your phone. Hey.
That's quite innovative. As we enter the final bend and wrap this conversation up, the resource envelope for the judiciary is something I won't delve into for now, but I would love to understand on behalf of the average Ugandan out there, where does one expect to meet costs and not to meet costs? Because many times legal aid and the pro bono services is quite confusing for the average poor Ugandan who wants the justice dispensed but cannot afford the lawyers, for example. How does one proceed? Those questions are going to be asked, but we can also have an opportunity to share with those that are watching right now.
Of course, that's a very tricky area and very gray, because the moment, based on your preamble, the perceptions, whenever a person is told to pay money, one important thing we are emphasizing, they should know for what purpose.
What are they paying?
What are you paying for? Okay? We have those people around the courts, masqueraders, unfortunately, including some practitioners. They extort money from the public over unknown reasons. But I want to tell the public and listeners that if you are under legal aid, okay, the legal aid service providers have their regime. And I want to assure the listener, the viewer, that they will have explained it to you, and they are very good people, because for them they are professional. If it is a pro bono is a Uganda Law Society scheme to help the indigent person. It's a requirement under the law for one to have credits to allow him get a practicing certificate.
Yeah.
You must have a requisite number of persons you have given free legal aid service as a lawyer or as an advocate. Then for courts, advocates charge professional fees, instruction fees, etc. That is outside the court area. Okay? And so we don't go into that. We only come into questioning those monies if a court in a civil matter has granted you costs as a successful party. Then we want to interrogate. Still, that is an avenue where we are helping the public against extortionist practitioners. You see? So we do taxation of costs. But besides taxing costs in matters where a court has ordered costs to be paid by the other party, we have fees payable, which we call filing fees. Any matter you file in court, except for criminal cases. So these filing fees, the fees schedule is clearly displayed at our courts. As you go to our accounts offices, the schedule is there. So somebody will tell you the amount of money to be paid in terms of fees when you see it. And the beauty with electronic court case management system, ICMIS, the ICT innovation I talked about, when you put in your pleadings, there are questions that ask and includes the value of the case, monetary value, for purposes of jurisdiction, but also for purposes of assessing and calculating the fees payable. At the end of the day, the computer or the system automatically generates the amount you shall pay. All right? And that amount is what you should take note and pay. Otherwise, you pay less, it will reject. The system will reject it. Okay. You pay more, the system will, because it's not what it has calculated.
That
but
system
also
rejects when you pay more.
Yeah, yes, because the system is designed also not to cheat Ugandans.
Not to cheat Ugandans.
Then we have other charges and fines. When they tell you pay a fine, how much is very critical. Please, gentlemen and ladies, listen carefully. How much has the judicial officer said, and how much does the record actually state? Because what is stated on the record is very key, is what the order of court is about. But stop listening to people from the corridors and wherever, those who want to cheat you. Then allow me end with this particular one, the issue of bail.
Great. Because
these are still monies payable in court. Bail is either cash or not cash. If the judicial officer granting bail states you are paying 1 million shillings, not cash, please, you are not required at that particular moment to pay any money. It will be required if you defaulted on the bail conditions, especially if you absconded from returning to court, no good reason, and then you are arrested, then you will be ordered to forfeit it because it's a bond with the court. Okay. But if he says cash, that amount of cash, don't pay it to anybody except into any bank with a URA account. And please, before you go there, get what we call a PRN number from the court, because it's generated on the system with URA. We already, under the ICT innovations, we're already having that integration. So your information data will be imparted to the system, which will connect with URA, telling URA you are paying this amount of money, and the PRN will be generated. That is what you pay. Now, but they will give you a PRN under the mango trees, in the corridors, nowhere. And these words, we have said them.
Yes.
But the public, I don't know. The public, that devil, I talked of that spirit National Court Open Day tomorrow or next month, we are going to exercise it.
I'm glad you've done a good job in exercising that. This particular edition of the interview has actually become the very first session of the National Court Open Day, because some of the questions that Ugandans will be asking have been put to the good head of public relations. Just a reminder, lastly, we are in Kololo.
We are in Kololo.
December 15th.
December 15th. Come and meet all of the judges and justices of the courts of judicature. Come and meet your registrars and magistrates within the central region who are close. Come and meet other stakeholders. Do you know that even the Judicial Service Commission will be with us?
With us.
Yes. And these are our employers. They are the ones who hire and fire. Okay. They are the ones who discipline us. Come and we have a fruitful participation. Public engagement. And
for the students and learners out there, because it will be holidays, you can also take some time and come and interact with the judicial officers.
Very important issue.
It could be very
students, please, you're also most welcome. Come and learn.
Yeah, as you seek to study law and become the Chief Justices.
The Honorary Chief Justice, the Deputy Chief Justice, Principal Judge, and all the judicial
officers. All right, thank you very much. Your Worship, James Eremie, Public Relations.
We shall have lunch.
There will also be some, judges will give you some lunch. Interesting there. Yeah.